All right, Campbell, what's up, man?
Hey, Derek.
All right, good. So, hey, this is an interview that I've been wanting to do with you for quite some time on estate planning, and wanted to get started by just kind of just telling everybody how we met and how we came to be colleagues and whatnot. So, I'll let you kick it off. Go ahead.
Sure, sure. Well, I've been a member of BNI for right around 6 years now, and it's been a great networking experience for me. Met a lot of individuals through that, and that's how we met. Not too long ago, you joined our chapter, and very quickly you rose the ranks, and now you're acting president of our chapter, Low Country Leaders, and it's been great under your
Absolutely.
leadership. And it's been a great opportunity for us to meet. I know in both of our works, you meet a lot of attorneys, I meet a lot of advisors, but I'm really grateful BNI offered us a more narrowed, private kind of area for us to really get to know each other, rather than just a handshake and a card, meeting each other
Right.
at a coffee shop or a mutual client just out of the blue somewhere. I think it's really kind of honed us to take the time to get to know each other better. And I think that's really good for us and our clients.
Yes, sir. Yes, sir. Absolutely, man. I always just love your thoroughness as far as how you go about explaining things to clients in great detail, myself included. Being a client of yours, my wife and I just redid our documents, and I was just blown away by the depth and the thoroughness of which you went through all of our documents and directives and kind of directed us on what to do and what not to do as it pertains to our estate plan. So again, man, just really excited to conduct this interview with you. And without further ado, man, I'd like to just ask you some questions and get your thoughts on some best practices as far as estate planning is concerned.
Sure, sure.
And by all means, anytime you want to just interject some thoughts or some additional add-ons that you might have to the questions that I ask, please feel free because you always do such a great job of explaining everything. I really mean that, man. Like,
No, I appreciate that. I think when I take clients on, I like to educate just as much as I like to, make documents and then help people make legal decisions. I like them to understand what they're doing and feel confident that they can talk to me and understand what they're saying and what I'm saying. And I want them to be able to explain it to their kids or their family member
absolutely.
almost as well or better than I could.
That absolutely.
I take a lot of extra effort to do that.
Absolutely, and you do such a good job at it, and that's the same thing in my practice as well. When I'm explaining what can be very complex topics to clients, I want to use very simple language that they can understand and that it's relatable, so that they too can go on and explain it to a colleague and just, like you said, to your point, understand what it is that we're trying to accomplish and why we're doing the things that we are doing versus what they may have heard some gurus talk about on social media. And obviously, that'll be something we talk about today during
Sure.
this interview. But without further ado, I just want to ask you. So, just tell us why did you become an estate planning attorney, and why did you decide to take this route into law versus another route into law? And just tell us a little bit about who you are and your practice.
Yeah, yeah. Well, I'm classically trained in undergrad at Wofford College with a double major in biology and environmental science with focus on botany. So in my earlier educational career, I was not geared towards law. I was doing a master's class down here at College of Charleston for a year, trying to get a double major and some other crazy topics and public administration, environmental toxicology, and things like that. But I was taking some environmental law classes and I really liked them. It was a new way of thinking on the science side versus the legal side of things. And I just really kind of got bit by the bug. So I took the LSAT, made a great score, got into University of South Carolina School of Law,
Mm.
transferred, and then started my legal career with that. Now I'm the first attorney in my family. I have some distant in-laws who are attorneys, but really I had no idea what it was like being an attorney till I went to law school. And through that, I took an estate planning course. But really, what really drew me to estate planning was a personal experience where a family member of mine suffered a stroke and was unable to handle their affairs. And they were a very
Mm.
important person in the family. lot of going on in the portfolio and their assets. A lot of people are kind of depending on what would be done with that. And thank goodness they had great estate attorneys out of Charlotte, North Carolina, come down and have all the paperwork ready, assisted the family and get everything set up. A
Mm.
lot of forward thinking. And I and a lot of my family owe a great deal to that. And when I got out of law school, I had friends that were becoming family law attorneys, defense attorneys, transaction attorneys, and none of that seemed to float my boat. But thought back to those estate attorneys that helped my family and said, you know what, that's the kind of attorney I'd like to be. I'd like to be one where I truly feel like my job is simply to help someone who has what they have and get it to the people they want or their loved ones the best way possible. And how can we
Mm.
do that simply and effectively and how they want it to occur? And I feel like there's no real victim in that. It really is a purely trying to help mentality and make things better for my clients. Not punishing anybody for making mistakes, not putting people in jail who may or may not need to be there, or getting people out of jail who should be there, or anything like that, or family drama on the set. There is some family drama in estate planning, but really not the side of divorce or things like that. So I really just felt like this was a very good, helpful area of the law that called to me as a person. And also I could really attest to how it works. It really works.
Right. Gotcha. And tell us a little bit about your firm. You are partner with.
Yeah. So I'm partner at Rutledge Coxe. Tom Rutledge is the founding partner, still there. Tom is a long-time attorney and trust officer. He served at some very major organizations, First Bank of South Carolina, Wachovia, Wells Fargo for a short time. He's been a state attorney for even longer than that. And then he's had this firm going on for almost 2 decades. And so we are a two-man firm. We're a boutique firm. All we do is estate planning, wills, trust, probate, legal documents. And we administer trusts. That's our niche. Not a lot of attorneys or law firms administer trusts or act as trustees and executors, but we do that for clients. We've got a lot of experience doing that. And so that's kind of how we separate ourselves from larger firms or firms that maybe in some terms a paper mill. They're just got the printers running and they're just printing off documents, and that's all they're here to do, just get you in the door, get you to sign a document, pay them, and go on your way.
Yeah.
A little bit more comprehensive. Our motto is from making your plan to administration. So we help you from the beginning to the end of the whole process, from drawing it up to setting it up to helping you put assets in there if you need our help with that, funding trusts and things like that, moving deeds into trusts and stuff, all the way to when someone passes and helping the family administer it.
Gotcha. Man, that's awesome. So it's fair to say that you learned from one of the best in the business.
Yeah, Tom. I mean, Tom's really well known. I don't think you can meet a lot of other estate attorneys or financial advisors or CPAs around the Charleston area who don't know Tom Rutledge. So he's got that great reputation. I'm his junior, so I'm walking in some big shoes, but he has trained me in the same way he has and put a lot of responsibility on me early in my career with him. And through that, being partner now, we see eye to eye and we sit at the same table. And, I'm happy to carry on his legacy through the firm, from now until I'm his age.
There you go, man. Again, about estate planning, you being the expert in that field. Why should everyone have an estate plan?
Well, an estate plan is a written, documented instructions that you have left your family, your attorney, the court, of what you would like to happen if something happens to you. If you are not there to advocate for yourself, who is going to be your advocate? What is the plan that they're supposed to advocate for? And how is it supposed to end up? Where would you want to see everything go and how it should be handled if you cannot be there to direct it yourself? And that everyone should want to have that. If you do not have that, you're relying upon your congressman and congresswoman at the State House of South Carolina to determine what the laws are if you do not have anything put in place. So you're just kind of leaving yourself up for, nameless faces, although you should know your local congressman, but these individuals who passed these laws in 1996, 2008, all these amendments and bills that have passed, that's what writes the law. And that's what you're saying. That's what I want to say what happens if I don't say anything or don't come to my attorney and have something put legally on paper.
Right.
And so you shouldn't just feel like you're just going to follow the default or even go through life not even knowing that default's there. There's a lot of misconceptions, a lot of urban myths about what happens if you die without a will. Some are worse than what happens if you do die without a will.
Right.
And those are, I'm here to dispel those as well. Although I do like people being a little more hesitant about dying without legal documents. So
Right.
it's doing the good part and getting people worried about it because they should be, even though
Right.
it's not as bad as some of those folk tales say it is. So it's still important. And even if and most people say, well, I don't own a home. I'm not married. I don't have
Mhm.
kids. Why do I need an estate plan? And simply put, because, without some of those defaults, wife, husband, children, things of that nature, the default in South Carolina, if you pass away
Mhm.
here as a resident here, may be something you did not expect. And it may be something you do not want to occur. And so, you definitely need instructions because if you would like for it to go to a sibling or a niece or a nephew or a friend or a longtime life partner, longtime
Mhm.
girlfriend, boyfriend, a charity, a cause, would like to create your own charity, your own foundation, you need legal documents saying that that's what's going to happen. If you
Absolutely.
don't, the default occurs and it may go to people you did not ever intend it for to go to.
Right. Absolutely. Well, speaking to that point, Campbell, about having instructions, what are some things that are typically included in a comprehensive will package?
Sure. I know I hinted at a lot in our previous conversation about the estate, where your assets go when you pass. But a comprehensive estate plan always includes a will,
Mhm.
a healthcare power of attorney, a durable power of attorney, and usually a HIPAA along
Okay.
with that healthcare power of attorney. And that's what I call a comprehensive estate plan. A will is a legal document that appoints someone by the court to be your executor, or what we call now personal representative. They're the ones that handle wrapping up your affairs, handling your debts and credits, filing your final tax return, handling your estate, distributing assets to the people you've written in your will to receive assets, doing all those things that require if you pass. But a lot of number of people are going to have an event in their lives that does not cause them to pass away, but causes them to become incapacitated.
Right.
Incapacity doesn't just mean you're unconscious. Incapacity can mean that you have a disability or an effect on your mental capabilities that you cannot
Mhm.
act on your own. Alzheimer's, dementia, Parkinson's disease, some kind of intense chemotherapy or cancer treatments. If
Mhm.
you suffer one of these debilitating events, you also need a healthcare advocate, someone who can make medical decisions for you. If the doctors who are treating you cannot get you to cooperate or you are not able to do so in your medical decisions. And then
Mhm.
your power of attorney, who can handle your legal and financial assets while you're in that state. And so
Yes.
those two individuals cover all the bases, your healthcare decisions and your financial and legal decisions. Um, just because you're married, just because they're your child, does not make them the default,
Mm.
especially if you have multiple children, or if you have separate accounts from a spouse. So if you have accounts that are solely in your name and not jointly owned with your spouse, the bank a lot of times will treat them as if they were a stranger off the street. I mean, they may
Wow.
recognize them, but their attorneys in the back office are going to be very hesitant and tell their tellers and their bankers, I know you know Mrs. Smith, but we have to treat this because she's not on this account as if she were anybody else coming to ask to handle Mr. Smith's finances in this account. So you need legal documentation saying that if something happens to you, you do indeed want this individual or these individuals to be able to take charge and take ownership of these items for your benefit. Now, we're not talking about them owning the accounts if you're incapacitated. We're talking about managing those accounts, having check writing authority, making sure bills are paid, responding to tax returns, IRS notices, collecting Social Security, making sure your required minimum distributions are withdrawn from your IRA accounts.
Yes.
All these things are very important to have a power of attorney to do, because a lot of institutions and their legal team will put a stop to you having access if they don't have the correct documentation.
Now, as my wife and I were getting our documents done, Campbell, you said something that was very poignant, which was the difference between a bank and a credit union. Kind of speak to that.
Well, it's from personal experience. I had a client who had a power of attorney that I did not draft, although they had already executed it. So they did not request me to draft them a new one, which was fine by me if that was their prerogative. Pretty comprehensive power of attorney. But however, when the wife was going to use it because her husband became incapacitated, they had a significant and large account at a credit union in the state of South Carolina. When she approached the tellers to have access to his accounts and manage his funds, their legal team looked over the power of attorney and sent it back in about 2-3 weeks of waiting with a big no on the front of the letterhead, stating that although the power of attorney did indeed give her authorization to handle bank accounts and financial institutions such as brokerage firm accounts, it made no mention specifically of credit union accounts, and therefore their legal team said it was denied because the power was not broad enough to include their specific accounts. And unfortunately, in those situations, when the husband or the person you're trying to represent is no longer in a mental state where they can legally sign a new power of attorney, and that's the only one you have to work with, your only other option is to go to court. And you have to go in front of the probate court, and you have to go in front of a judge and give a reasoning of why either the judge needs to make a ruling on the power of attorney that you have authority. If he or she will do that, which is a stretch, most likely what you're going to have to do is open up a court case called a guardianship conservatorship, which is pretty much a court-appointed power of attorney. Right. However, it costs an extremely large amount of money compared to doing a simple power of attorney, and it takes a long time. Another attorney to represent the incapacitated person has to be involved. A guardian ad litem has to be involved. Potentially weeks waiting for a court hearing. Doctors have to interview the person who's supposedly incapacitated. It is quite a circus compared to just a very well-drafted power of attorney you can sign in an afternoon real fast.
Right. Just getting some documents and some instructions on file. And in regards to power of attorney, are we talking about general power of attorney, or is there a special type of power of attorney that's designated for financial matters?
Sure. So the terminology, you'll go to 5 different attorneys and five different words for something. It really is like that. And there's some uniformity among the practice in certain terms, but most likely you've dealt or have seen what's called a general durable power of attorney. And that power of attorney references all financial matters generally. If you're getting one offline or a quick LegalZoom kind of document, there'll be some check boxes to put your initials beside for certain powers. So you can cherry pick. Yes, they can handle my bank accounts. No, they cannot handle my credit cards. And some of those are customizable in that way. Generally, it's done because an attorney's not drafting it for you or speaking to you exactly about what you want. You're just printing off a document and then filling in the spots that apply to you, which is okay in certain short matters. But as I said previously, having a document that is broad, that is flexible for different situations that you're going to run into or may run into is much better to have than something that's very narrow. And that's usually when people run into trouble, is when it doesn't say enough.
Right. Absolutely.
If you're out of town and you live abroad and you need someone to sign a closing document for the buying of real estate, there are specific power of attorneys to handle that one transaction that you could sign. That's a special power of attorney or a specific power of attorney. But more common than that, and one most people don't know about, but is a good practice procedure is what's called the springing power of attorney. Now, the
Okay.
springing power of attorney is a durable power of attorney. However, it is only effective once an event occurs that you've designated. Most typically in the state of South Carolina, that event is when two doctors have interviewed you and both doctors have signed legal affidavits that are notarized stating, I interviewed this patient on this date. They do not seem to have the capacity to manage their affairs. And once two doctors sign notes like that, your agent, who your power of attorney is supposed to be, would take those notes with the power of attorney to the Register of Deeds office, the courthouse, and get it recorded with those doctor's notes. And then the document says, if all three of those documents are together, then this person is my power of attorney, and now they can act on my behalf. The other durable power of attorneys that don't require doctor's notes are effective as soon as it is stamped in the courthouse. So one is for simplicity and speed. The other one might be a case where an individual is nervous about letting go those kind of powers, and they want to be sure that they themselves do not have the ability to make their own decisions if someone's going to act on their behalf that way, which is very common. And either one is perfectly legal and perfectly 50-50 almost between my clients. And so it all depends. The determination does not always have to be two doctors. It can be a single physician. It can be your primary care physician. Some power of attorneys are drafted so that family members are the deciding factor on capacity. They would like to leave doctors out of it completely. So they have something like a unanimous family agreement that if all the kids and the spouse all agree that the other spouse is incapacitated and is not, handling their affairs correctly, that they can sign affidavits and file that. That's less common, but if some people are more private and don't like an actual doctor's determination of capacity, then they'll go by that.
Dang, man. This is why you have to come and talk to a professional, because you don't get that thoroughness online with one of these online services out there. I mean, and that's exactly why you want to come and talk to a professional. Next question here. Why shouldn't you name minor children on any type of documents, whether it be your IRA account, your 401ks, or your life insurance policies? Why should you not do that?
Sure. Well, naming a minor directly with no other connotation of how the funds are supposed to be managed or held for their benefit is a classic mistake that sets the family up to go to court. And it's not because that there's a police officer or some kind of institution is going to tell them, oh, this is wrong. It's mostly the case that when they come to collect the money that was named in the minor's name, once the institution discovers that the person is a minor, they won't release the funds until they see proper legal documentation of who they can release it to besides the minor. Now, you would think, oh, well, I'm their parent. I automatically have the right to handle their funds. That is not the case. Those funds belong to the child. And the bank and the courtroom, although you are the parent and are a default first choice to be the person to handle those funds, you do not automatically have charge over their monies. These are not like funds that you put in there for that kid yourself. These are something a grandparent left them or another family member. And so these funds are coming from a third party. The bank and the court are going to want to make sure that those funds are held and managed for that child's benefit and their benefit alone. And there's a lot of legal procedures that go around to prove and protect that. The main one, of course, is, like I previously said, a guardianship conservatorship. Okay. And that's because the child is not old enough to create a power of attorney. So they don't have a power of attorney. Although you as the parent or their guardian and ward, the court still requires certain formalities for you to go through to show them and prove to them that you're managing the funds correctly. And I'm sad to say, and I tell my clients all this all the time, the courtroom is going to treat you like a bad actor. And it does that. And it doesn't treat you like that, but it needs evidence, right? The court's all about proof, right? And so they're going to give you the benefit of the doubt, but there needs you to show them that you're a good actor. And it's because, sadly, the court sees a lot of bad actors.
Yeah.
Family members, even parents that are going to take advantage of a child and spend their funds for themselves and squander what
Hmm.
was supposed to be a direct gift to that child, that individual. And the court's just got to be cautious about that. So they're going to
Right.
treat you like you're a stranger almost in some ways. So to be a guardian's conservator, they're going to want to see a credit report. They're going to see
Mm.
if you've ever filed bankruptcy. They're going to see if you have a criminal record. And all
Wow.
these other factors are going to come into play, whether that court's going to let you be in charge of that child's funds and take that account or take over that account for that child. Not only that, but the court also supervises those accounts. So they're going
Mm.
to require an accounting every year of the funds, what it started in the year, how it ended in the year, and what you spend on in between. The court can even put precautions on there saying you're not allowed to spend more than $500 out of this account unless you get the judge's signature. And so for a lot of parents handling funds for minors, that's a lot of administrative and bureaucratic headache to handle making an expenditure for a child, even though it's legitimate, still requiring that judge's note or signature to come from the courthouse.
As
So,
you were talking, Campbell, I just kept hearing cha-ching, cha-ching,
oh yeah,
cha-ching.
well, I mean,
It's
how many
like,
times have you gone to the probate court to handle a guardianship and survivorship case? And it is a case; it's a court case. You get a hearing in front of a judge. There's a guardian ad litem who's usually an off-duty attorney asking a lot of
mm,
questions and stuff. And so a lot of people need legal representation. And although, generally when I do those cases, I reduce my fees just because of the sensitivity of the case and also
right.
the kind of court it's in, but it's still expensive and it takes a lot
Yeah.
of time. And it's a lot of mess that families really did not expect just because they put Susie Q as a beneficiary when they should have put something else.
Speak to that a little bit, Campbell. What should, instead of naming your minor child on life insurance policies or 401k accounts, what's something that they could do instead that would be better suited and avoid all this headache that you just ran down to us?
Gotcha. Well, my default answer is to do what is a minor's trust, and there's a lot of things that do that. You don't have to have a trust yourself to create a
Hmm.
trust for someone when you die. That is simply called what's called a testamentary trust, which is a trust that's created from a will. So you could have a simple will that creates a trust later after you die for a minor beneficiary. So you could say in your document, if any of these people are under the age of 21, then my will shall create this trust for this benefit of this person and until they turn 21. And if they're already 21, it doesn't happen. It's all good.
Hmm.
So if you have trusts like that set up, typically what I would say is for beneficiary designation of life insurance directly, you could direct it to the estate, which a lot of life insurance advisors would tell you, why are you doing that? And typically because one of the big points about life insurance is it avoids probate, right? It doesn't get involved with the probate court case because it's a separate policy that goes
It's
directly
contract
to
law.
beneficiaries outside of the probate court, which is in some cases is great if it's an adult beneficiary.
Right.
However, if your intent is for that life insurance to go to a trust to someone if they're under a certain age or specific beneficiaries, then have it go to your estate will allow the will to distribute those assets in trust like you directed.
Hmm.
Or if you have a revocable living trust yourself, having that trust collect those fees and then spin off smaller trusts for minors. That's one way. The state of South Carolina has also released, not too long ago, in the past few years, new custodialship statutory language about naming custodians of accounts. Kind of like a
Okay.
529 account has a custodian.
Right.
These accounts would be custodial accounts till the child turns the age of majority, 18, things like that. But that requires very specific language in the beneficiary designation of the policy, of the life insurance, of the bank account. If you put POD, pay on
Hmm.
death, transfer on death, you require to say for the benefit of Susie Q, held in the custody of, or to be held in the custody of so and so. And there's very specific statutory language for documenting that. And if you don't have it, then the default is, oh, it's supposed to go to Susie Q directly, and then we're going through the whole guardianship serviceship case. And
which is the
also,
headache.
and also to change those beneficiary designations, you have to fill out forms and do that. And so doing custodians is fine. However, doing a trust as the beneficiary or your will allows you to just change the will or the trust, and you don't have to refill out the beneficiary forms. So if the policy says pay my estate or pay my trust, you just have to change the document that controls the trust or the estate.
Okay.
So all your beneficiary forms can stay the same. It's just the actual document that makes the distributions, the trust or the will, is edited, and that's done privately, and it's done very easily with your attorney, and that makes that a lot simpler process. And it can have backups like Plan A, Plan B, Plan C in case something this or this or this happens. And the beneficiary designation policy, and as you know, you probably given your clients, forms to fill out. It's not that customizable. It's got one slot and it says right name here, and you can't write
percentage here.
Yeah, and you can't put a whole paragraph saying, oh, but if she graduates college, do this.
Yeah.
If she gets married, give her this much now. You can't do any of that. It's just, one black or white, get it or don't get it.
Right.
So if you want any kind of instructions like that, you've got to have a will or a trust to do that.
And we're going to talk about the difference between a will and a trust here in a second. So we talked about minor benefit, why not to name minor beneficiaries. And I guess you kind of already spoke to what to do instead as well. Give me an example of some misinformation that may be floating around out there on social media that either clients have come into your office and told you, or just something in general that you hear and you're like, man, I wish these gurus would just stop this nonsense.
Yeah, I guess some of the worst case nightmare scenarios that people come in is, oh, if I don't have a will, everything goes to the government. That's not true. Now, I'm not saying it won't ever happen. It actually, right, under the law, if you die what's called intestate, which means no will, no trust, no document saying what happens to your estate, right? You go through the South Carolina intestacy statute, which says, okay, what do we do with this? The default in South Carolina, if you're married, is half of your assets, half go to your spouse, half go to your children, no matter what age they are. And if they're minors, guess where we are? We're opening up a new court case for guardianship conservatorship. So you'll have a probate court case. Your wife or whoever it is, your husband, will be dealing with a probate court case, and then a guardian ad litem court case, a guardian conservatorship court case in the same courthouse, but two different cases, maybe two different attorneys. I could do both, but not all estate attorneys do guardianship conservatorship. And it's just a lot of mess and headache. If you are a single individual and you have no children or wife and you pass without a will, it goes up your family tree to your parents. And if your parents are not alive, it goes out and out. And that way, if you had a distant relative, a second cousin or a niece or something, it would reach them eventually. But after it's gone through the whole process of a probate court case with no will, which is in itself a little messy, but only if you die with no heirs, no legal representative can be found to take the estate, then it will go to the state of South Carolina if you pass away here. And that's the default. But for some reason, there's some kind of horror story out there circulating, scaring people, saying if you die without documents, the South Carolina government gets, or the federal government. That's just not true. No one ever claims it for too long. They will, secure it, but that's a long time coming. So that's one I dispel quickly. I'm glad it got people to come talk to me. That's
absolutely.
But I'm not letting them keep them up at night, making them think that's going to happen. Another one is that probate is a terrible nightmare. Probate can be a terrible nightmare. Any kind of court case can be a terrible nightmare if you are not prepared for it, or if your family's not prepared for it. Meaning, if you haven't done a will, if you have not secured title on assets, meaning that if you have an asset like a real estate or property in South Carolina, mostly that's heirs property that does not have clear title, that someone's parent or grandparent once owned and no one's done anything to secure who actually owns it or how much they own of it,
Mm.
that can be a nightmare because that leaves a big question mark in the estate, and the judge is not going to let the estate close, or not just going to let it open and close very quickly unless those things are addressed and found out and figured out. And so those could drag on for years and years and years, and not having a will, or having a very, sometimes having a will, but a poorly drawn up will is
Right.
worse than dying without one. Because the ambiguity, the version A, version B, version C, the handwritten one, the one they printed offline, the pencil, edits they made one Christmas versus the pen ones they did over Thanksgiving. Those all it does is just tease up the ball for litigation in court.
Right.
And nothing in law is more expensive than litigation.
Right.
Time consuming. And so ambiguity is the enemy for smooth estate plans, smooth probate, things like that.
Gotcha.
And ambiguity like that can be very, latent in your documents. One example is in the state of South Carolina, if your will, even if you have a will, if your will does not allow your executor or personal representative to sell real estate, then they cannot sell real estate, even though they're in charge of the estate. So even if the kids or the family wants to sell the house, the executor is going to say, well, the judge has just told me I can't sell it unless I file a petition to sell real estate. We get it appraised. We send out notice to all the creditors for the estate. They have to consent to me selling the house.
Wow.
So, your Discovery card or your Chase credit card company could be saying yes or no of whether the family can sell the house or not. Even if there's a mortgage on it, the mortgage company obviously has to be notified. And so all that has to happen just because the family and everyone agrees wants to sell the house. Just imagine if a distant family member who is a beneficiary, or a child who's not really part of the family plan but is a 10% or 1% beneficiary, doesn't want to sell the house.
Right.
That's going to be a mess to get their consent to do it. So your will needs to say, if you want this, my personal representative has full authority to sell any and all real property, blah, blah, blah. It's a lot of legalese, but it's just covering all the bases. And there's a lot of wills out there that might not have that. If you're printing it off online, I can't guarantee that it's going to be in there. And then that's one that drives families crazy because it's a timely process. And when you're selling real estate, it's better to sell real estate in the spring and summer than in the dead of winter. Who's going to buy a house around Christmas,
Right.
So if you're trying to get this house on the market, and you come to me and you've already got a realtor lined up, you've already got a buyer who wants to buy it, but you show me the will, I'm like, well, you can't sell this. We have a court hearing before you can sell this. That blows everything up. And I'm sorry to say, but a lot of real estate attorneys and realtor friends of mine have come to me in that same situation. I just had to be the bearer of bad news and go, listen. They're like, can we do it in a week? I'm like, no. Like,
no.
2 weeks? I'm like, no. 3 weeks? No. I said, probably 2 months.
And that, Campbell, to speak to that, that was one of the things that stood out to me when my wife and I came and signed our new documents, was just the breadth at which you covered and had already planned, because whenever you plan something, you want to plan with some foresight and some forethought in mind.
Right.
But you had checked all the boxes that I had originally thought about, even down to digital assets, which I was like, man, Campbell is way ahead of the game, because, as we move more into this digital and AI world, that's going to be something that people may have. They may have digital assets, but to see it already there in the document and how thorough, being able to sell real estate, just kind of speak to that. What are some of the things that, if you just talked about 5 things that are included in your will package that may not be included in some online service that people may see out here?
Sure. Well, I mean, when I sign documents with clients, as you know, I thoroughly review the document with them, and I go over key factors, things they should know that I'm not sure any online agency or document drafting software is going to alert them to really the significance of them and what it could mean. And their right and their ability to edit those as they see fit and what meets their criteria. I would definitely think some of the legal terminology of per stirpes versus pro rata and how funds are distributed to beneficiaries is something that most people aren't educated on, unless you've really been to law school or you're involved in estate planning. You really don't understand how that distribution works or the differences between it. And that can lead to heirs getting a lot less or way too much of your estate than you thought, just given how those terms mean how assets should be distributed. That's a major one for distribution. The other one is when people are clicking these options, I find them sometimes mixing up things about, whether everything goes to your spouse, whether everything goes to your spouse and the kids, whether some things go to the kids and some things go to the spouse. And also, what happens is sometimes these programs are offering trust language to people who don't really need trust language, and they're really overcomplicating their matters and could create trusts that hurt them tax-wise in the future, could cause a lot more legal work than is necessary that their family should be going through, and also just have language in that's incorrect. It's just not what they wanted to happen. And I've read out loud a lot of wills and trust individuals and explain to them what this sentence is saying, and seeing their eyes get big and think, well, that's not what I intended. And say, well, this is what you said. This is what you signed, saying that this is what you would have written this by hand if you could, that this is what happened. So just education is the most important part, doing that. And so, people who are your executor, who serve as your executor of your estate, they get paid. They can take a cut of the estate as payment to do that job. So you may intend, oh, well, Uncle, Ben's going to do it. He'll do it. He'll do a fine job. Just know Uncle Ben could take 5% of the estate or more if he got court approval as a fee. And so, if you don't like that, you can set them out. You can set the expectation and things like that. Same thing with bond. Bond is a insurance essentially on the estate, saying if something happens to the negligence or wrongdoing of my executor and something is damaged or lost, or funds are transferred and intercepted by a scam artist, or a house burns down in the care of my executor, or they abscond with the money, they steal money, the bond's going to cover the estate. And so the executor or trustee is bonded. That's an option you have. I think a lot of people might just skip over that section and when they're clicking buttons to fill out their documents. That's a big one. State jurisdiction is a big one as well. Also, taxes. Now, right now, we're in a very friendly tax environment for estate taxes, especially living in this state. But when you draw your will up, it's probably not going to be the same tax year that you die.
Absolutely.
So you're going to die in a time where you don't know what the tax law is going to be. So you still need to have some flexibility and some understanding about what that language is going to do when there's a big exemption and where there's no exemption, or where there's a small exemption. So you just kind of need to understand what that says. And part of that is saying who pays taxes if taxes come due. There's one phrase to use in estate planning where there's no appropriate of the estate tax, which means that everyone pays equally. So, and that makes sense if the estate's being split equally. Everyone gets 25%. Everyone chips in for 25% of the tax. That's how it goes. But you could say, no, it goes by pro rata, how much you got. So if someone inherited 50% of the estate, they're going to pay 50% of the taxes due. When you're going through your legal documents, drawing them out online or writing them up yourself, I don't know how many people are conscious of doing that. They just might be picking whichever one they think might be better. And they could be leaving a tax burden to one person that they did not expect, or they may be distributing funds to individuals where, they didn't want taxes to be paid equally. And so that's just something that your attorney would probably advise you on.
Exactly.
There's some obscure ones, but I'm sure there are ones that people aren't fully educated on. Everyone should probably know what an executor is. It's the person who handles the estate, and then the beneficiaries who get the funds and things of that nature, and then including like underage clauses, because most likely and hopefully your estate documents this way if this is what you want, but if one beneficiary dies, typically some language might say, well, then their share goes to their kids, which could be your grandkids or your nieces and nephews. If that's the case and they're minors and you do not have minor trust provisions as default in your will, even though you might say, and I've had clients say this to me, why do I need that trust language in there? I'm not leaving trust to anybody, and all the beneficiaries are adults. I said, that's fine, but the way this will is set up, if they die or one of them dies, their share goes to their kids, who are how old? And they usually go like, well, 14, 12. I was like, okay. If something happens and they die before you, and then their share goes to their kids, you're going to want those provisions, or you're just setting their family up to have to go through a bunch of court cases.
Exactly.
And so that forward thinking, like you said, that flexibility is something a state attorney should be educating his client on if they're planning documents or reviewing documents or anything in between.
Definitely, man. I get excited talking about this stuff, and my wife, she's kind of like glossed over whatever, but even she started to come around just just thinking with foresight of the things that could happen, because that when you're planning, and this is what I tell my clients as well when we're going through their financial planning, is you have to think with foresight, not only about today, but you got to think about tax implications today as well as later on into the future when you're not working, and how can we minimize those taxes, because otherwise taxes and inflation will eat your lunch and erode your wealth over time.
Yeah.
And if you do proper planning with estate planning, it's almost like a chess match. You can position things in place to help avoid some taxes, maybe not for yourself, but maybe for grandchildren down the road with some more sophisticated type of planning.
Right.
Which brings me to my next point, and I got 3 more questions here.
Sure.
First one being, when is a trust appropriate, and why is a trust? Why would a trust be a better option than a will in some instances? And what are the benefits to that?
And this is when I get off the street a lot, and it's people says, "Oh, I need a trust," and usually when they come in, I take their word for it, but I always ask some preliminary questions. So just some reasons for a trust in my book I think are valid through my experience of doing trust and being a trustee and setting up tons and tons of trusts and drafting a lot even more. So people want to come in for trust, one, usually because their neighbor has one and they said they need to get that's one I get a lot. 2, they may say, read online, or I heard online, or I want to avoid probate, and I know trusts avoid probate. But like I said, probate's bad if you have bad planning. Probate's not bad if you have good will planning. But some people want to avoid it. There are fees associated to it. They are not egregious unless your estate is quite large. Then they're kind of a sore number to write a check for, but they're not going to take 50% or a giant piece of your estate. It's not like that. So those are usually the reasons, and those are good reasons. Avoid probate's one I'll accept. That's acceptable. And usually they say, oh, I want to avoid taxes. Well, there are certain trusts that will help avoid some taxes that my living client could be affected by, but mostly the taxes that trusts will help you avoid are not your taxes. It's taxes to your estate, to your spouse later, or to the kids later.
Kids, right, yeah.
You're really planning for taxes for other people's taxes, not your own, when you do trust and estate planning. So that's some kind of myth I kind of wave away early on. Explain to them I'm not going to eliminate their income tax, doing trust. But that's one we kind of talk about. But the reasons to get a trust, avoid probate's fine. More comprehensive incapacity planning. And I talked about power of attorney and healthcare power of attorney. Those are good documents to have. Even if you have a trust, you should have those documents. Right. But having a trust in place as kind of an overarching umbrella, as an entity that owns your bank accounts, your savings accounts, is the beneficiary or owner of your life insurance, is the beneficiary or owner of land, of annuities, all these things. and having you as trustee or your spouse, and then a designated backup trustee in case you or your spouse become incapacitated, is a smooth transition, and it allows everything to kind of be under one umbrella and have that person primed to take over those accounts and those things and responsibility for those things very easily without providing a power of attorney, getting it recorded, doing all of that. And it's a little bit of an easier transition. Typically, this is very useful for having a child or friend or other person helping an elderly person manage their portfolio, manage all their assets, is having a co-trustee where my client's still with it, but they do want this person to be their number one, have control, be the same kind of person who can log onto accounts and write checks and do all this stuff. And it doesn't require much to do it privately. It's pretty easy to do. That's a good benefit. And then if something sudden happens, having a child step in for parents who may linger for a long time, needing assisted living, medical help, having a trustee, keep the house in order, accounts, R&Ds, pay bills, file tax returns, doing all that kind of stuff. That's still a great thing to have. So incapacity planning, more advanced incapacity planning is good. Definitely people with out-of-state property. That is a huge one. I nod. And if you have out-of-state properties, I might just say that's enough to get a trust.
Okay.
Just because the way it's set up jurisdictionally, let's say you have a South Carolina house and you moved here from another state and you kept that house, but you turned it into a rental property. And let's say you've been living on the coast for a while and you want to buy a mountain house or something in another place like North Carolina or Georgia or Tennessee, and you have a property there. Now, if you pass away or you and your spouse pass away, your beneficiaries or whoever's going to handle your estate is opening a probate court case in South Carolina,
all three states,
the state you came from, and the state where the other property is. So you have 3 court cases going on. And guess what? I'm licensed in South Carolina. My partner's licensed in Virginia and South Carolina. But unless your attorney is licensed in all these states where these other jurisdictions are going on, if there are legal matters or legal issues to be handled in those states, it could cause you, your estate and your family, to hire multiple attorneys. And there's nothing. What's more expensive than an attorney? Lots of attorneys,
Right.
And so that's just a cost that can be avoided, because if those properties are held by the trust, the South Carolina trust, or wherever state you're living in, that trust, then when you die, the ownership doesn't change hands. It's still in that trust, and your backup trustee's in charge of it. There's no probate. There's no reason to get an attorney in there involved unless we need to do a deed later, but that's a very easy little thing to do. And so it's definitely a reason. In some states, Florida, New York, California, Virginia's got some weird Commonwealth laws, but some states are just a nightmare to go through the probate court. It's just the way they've done things. It's making South Carolina look very simple and easy, which through my experience it is compared to some other places.
Oh yeah.
So I have some hot button states that if you tell me you own real estate there, I will be already suggesting, well, maybe we should do a trust just to avoid that.
Good stuff, man. This is awesome, Campbell.
Yeah.
All right.
Oh, and just to tag on that, yes, trusts are for high net worth clients. The estate tax, make estate tax planning. Wills can do a lot, but wills just kind of adding an extra step to the whole process when the trust is just kind of getting to the matter of it quicker. And certain tax elections that can be made, and certain kinds of trusts, revocable versus irrevocable, that can be made to grandfather in funds from future estate taxes and things like that, which are different reasons to have a trust and do trust planning, I would think.
Absolutely, man. Absolutely. This has been so good, Campbell. I want to end on, everybody likes a good story, right? So you do such a good job of telling stories when we're at BNI about your experiences with your clients. So the first one I'd like you to kind of give us a story on is, what's one of the most, I don't want to say most tragic, but a case where you felt things could have been done better to avoid a bunch of headaches. So let's speak to one negative thing and then we'll end on a positive.
Yeah. So in general, the biggest pitfalls in estates are, like I said, poor documents. And usually it is a home done will or something that someone's edited, without doing the proper legal channels. I've had ones where the document was written on in pencil over several years, scratched out, rewritten. No one could tell when or how or what was the most current version of a former version. Thank goodness for that. The family brought it to my attention before the individual who drafted it died. And I was able to meet him at the hospital, I would say 48 hours before his passing.
Wow.
He was in a condition where he could sign documents. I was able to discuss with him the issues with it, and I was able to type it up nice and clean, get it very coherent, up to date, and he was able to sign it. And I brought my paralegals with me to witness and notarize it. We got it done. I don't like doing those last minute ones.
Yeah.
I was able to salvage that situation, but it could have been very messy. Um, I've seen ones, and typically the messiest one, and I'll say this, not to my own horn, is when individuals name multiple children as executors or trustees all at the same time. And they've just completely ignored that there might be some tension in the estate plan, in treatment certain siblings feel they got or did not get financially throughout the life of the parent, whether those are justified or unjustified. A lot of those negative feelings and resentments come out very quickly. And when you have multiple individuals at the steering wheel, it can make the car go off the rails real fast. And most, almost generally, all estate litigation I've seen is between siblings. And it's when one sibling's in charge or they're both in charge and they're not on the same page and they don't like the instructions they've been given by the parents or the individual who wrote the document. And those are usually the worst cases to deal with. A solution I have with that generally is third-party executors and trustees. Name your attorney. If you don't want to name your attorney, name a bank, name a trust company. I mean, name somebody who does not have skin in the game to have a grudge or have a certain mindset, or who hasn't been living the past 40 years expecting things to go this way, and they've imagined it over their head again. Oh, when mom and dad pass or when Uncle Billy passes, we've had a conversation. He was going to give me this or give me that or leave this. And then they get to the document and it's not what they've been expecting for 40 years. It's hard to correct that mentality for them to get over that, and it leads to a lot of litigation sometimes because they don't want to do what Uncle Billy directed or what mom and dad directed, and or the sibling who's the beneficiary doesn't want to accept what they've been given, in a sense that they don't think it's enough, or it's not exactly what they wanted. And so those are the ones that really go to litigation, and those largely can be avoided by third parties not having any kind of bias that are going to administer it as stated. And that doesn't mean beneficiaries won't reject it or be unhappy with decisions made by the individual who drew up the document, but at least it's felt more of a, avatar for the deceased, speaking to them, their attorney, this unbiased entity that says, why would I get anything from telling you how it is? I'm not getting any advantage from just reading you what this document says and enforcing it. And so it's sometimes it's easier to accept when it doesn't feel like it's coming from a party that you think has a interest in for it going that way.
An internal bias one way or the other.
Exactly. And so that's one that I see a lot. But I've had clients come in with crazy estate plans signed in 1990, 1970 who have not looked at them since. And thank goodness they brought them in and we were be able to bring everything up to date and take off people that weren't alive anymore and all these other things that just
Wow.
could have been a real mess if they had never looked at it till the funeral.
Mm,
Yeah.
awesome. Good stuff, man. Tell us one more sophisticated plans that you or cases that you've dealt with, or you've created multiple trusts maybe for this reason or that reason. But
Um, one of the ones that comes to mind is doing some of these special needs trusts for
mm,
individuals who have special needs, who are on
children.
Medicaid or other kind of government assistance. Those are very necessary to keep benefits. It requires some advanced planning and definitely
Mhm.
should be put in place. I oftentimes will put in my documents some kind of latent hibernating language that just kind of sits there unless it's needed, saying, by the way, if one of my beneficiaries who I've named develops special needs or has special needs by the time I die, their trust is turned into a special needs trust. And that's good to have
Mm,
its flexibility. Doesn't mean it will happen, but we got a
right.
safety net in case something changes between now and then and y'all don't come in and change your documents. That's important. I like putting those in my documents. I think it's a very responsible thing to do, forward thinking. Those are important to do. Very complicated in some situations. When it comes to net worth and financing, there's a lot of gift trust ideas. There's a lot of alphabet soup trusts I can describe to
Yeah.
you. There's ILETs, irrevocable life insurance trusts. That's a way of moving very large amounts of money out of your estate if you're thinking that it may be taxed, creating tax-free income or tax-free monies that can be used to help pay taxes or use premiums, payment on large premiums as a way of putting your money in a different vehicle that's non-taxable for estate taxes.
Absolutely.
That's a big one people have used for a long time.
Hmm.
There is, when we're doing the grandkids, there's something called the generation skipping tax that a
Yeah.
lot of people have never even heard of. It's our great government taxing us even more if we're giving it to someone who's not our child, who's under a certain age or a certain amount of years younger than us. That has to be played into factor in some cases when you're giving to grandchildren. Setting up educational trust, setting up trusts for beneficiaries who might squander the wealth pretty quickly,
Ooh, yeah.
setting up trusts that are asset protection trusts. There are trusts that are protected from the beneficiary's creditors, protected from divorce, bankruptcy, things like that that can be drawn up so that that beneficiary does not have to worry about losing those funds from unforeseen consequences down the road.
Hmm.
Those are important. Doing spousal trust for second marriages. So if you have a mixed family and you want to leave a trust or leave money to a spouse, but you want to be very, very sure that when that spouse is gone, it goes back to your side of the family,
Right.
you have to have trust language for that. And you really, really need a third party trustee to administer it so there's no bias in how that goes. Those are important ones. You've got these grants and idiots, these
Hmm.
advanced trusts, grantor retained annuity trusts, intentionally defective grantor trusts, idiots, grants. These are all ways, simply put, these are ways of selling an asset to a trust, your own trust, and
Mm.
then the trust paying you back for that. But in the meantime, the asset you sold is really worth or becomes a lot more than what it was sold for.
Hmm.
And now you don't own it anymore. And so now you sold someone something that was $100,000 and then now it's worth $1 million, but
Wow.
you only gave away 100,000
Hmm.
essentially, and you got your money back with interest. And so it's things like that that you do for advanced planning. And usually that's with like business
Ultra
interest
high. Yeah.
goods, stock that might go public. I've tried to talk people about Bitcoin and cryptocurrency on things like this.
Mm.
If you sold, 1,000 Bitcoin to your trust 10 years ago, and
And you got
then
quite the
now a
tax bill.
thousand Bitcoins in that trust, it's a lot different number than when you sold it to it, and things like that are forward thinking things that people want to talk tax and talk future,
Yeah.
grandfathering in funds. I could talk all day about it. But that's the more advanced side that anybody can pick my brain about anytime they come see me.
Gotcha, man. Campbell, give us a good story. Like in B&I, sometimes you stand up and I'm like, man, I wonder what Campbell's gonna say today. Give me a good story. Something maybe a little comical, but also a little like, man, I had no idea.
Oh man. Really, those would be pet trusts. So pet trusts are a very interesting thing.
Pet
Pet
trust.
trusts,
Wow.
legal in South Carolina. A pet trust can be set up for the care of animals for an indefinite amount of time, depending on the animal. So one pet trust that I was privy to was for a Cocker Spaniel that was inherited a home on Kiowa Island in South Carolina. And if you
Wow.
just Google the average property value of a home on Kiowa Island,
Yeah.
you'll see what I mean. And with enough funds to maintain the property, pay for the caregiver, and vet bills and everything. And
Wow.
my firm, we were the trustees of that trust for a while, and as long as that dog lived. And the dog was taken out of the house, got to stay in the house, was walked on the beach, fed the finest foods, groomed, vetted, the rest of its life, lived a very comfortable life. And then after the trust was handled, we liquidated the property, and then everything went to a charitable foundation. And so things like that are out of the norm, and some people
Yeah.
might gawk or laugh. But that's what I love about estate planning and being a trustee and handling trusts. It is the execution of someone's wishes past them. It is keeping their
Right.
dream and their intentions alive and doing the best to represent them and what was important to them when they're gone.
Right.
And whether that's taking care of a grandchild or whether it's taking care of a pet,
Mhm.
it's doing what they wanted, and hopefully letting them rest easy, knowing that that's going to happen.
Gotcha. Well, awesome, Campbell. Thank you so much, man. I appreciate it. As always, you just do a great job of explaining and being very thorough with everything you do. So appreciate you taking the time to sit with me and have this conversation, buddy.
Yeah, Terry, absolutely, anytime, man.
All right, man. Well, that's it. And tell people how they can find you and find your firm.
Sure. So we're located in Charleston. We're actually on the West Ashley side of the Ashley River, 1700 Ashley River Road, Suite A. Rutledge Coxe is the law firm. You can go to a website, rclaw.com. That's Rutledge Coxe, rclaw.com. Happy to got a lot of good information on there. I'm very easy to get a hold of. If you call, you'll get my secretary and she'll book a free consult. I do phone consults. I go see people at their own homes if they're not too far away, and I don't charge extra for that. It just takes a little finagling with my booking. But happy to do that for individuals who can't get out, elderly or, infirmed individuals. Happy to do that. And I even do visits to the hospital, like I said previously,
Mhm.
if that's necessary. So I'm very easy to get a hold of, very easy to make an appointment.
Great, man. Campbell, again, man, thank you so much.
Yeah,
Appreciate it, man. You're
absolutely.
expert at what you do, and I really appreciate it.
Thanks, Terry. I appreciate that.
All right, man. Take care, and I'll see you at the next meeting.
Sounds good, man.
All right, buddy. Take care, man.